The Federal Fair Housing Act covers a wide variety of activities and has a wide-reaching influence in the world of real estate. Let's first describe a term known as disparate impact. Disparate impact is a legal concept that has been interpreted as recently as 2015 by the U.S. Supreme Court. In terms of the Federal Fair Housing Act, a rental policy, if we're talking about real estate agents who are working with tenants, or property management staff that might be working with prospective or current tenants, must be conscientious of any rental policies that could have a disproportionate adverse impact against any group based on any of the protected classes. Those include race, religion, national origin, color, sex, familial status, or disability when there is no legitimate, non-discriminatory business need for such a policy. This applies regardless of intent. Therefore, in a disparate impact case, a person can challenge any practices that he or she believes has a disproportionately adverse effect on those protected classes. In particular, landlords need to be careful to not discriminate based on a prospective tenant's criminal background. The Department of Housing and Urban Development has provided guidance in the use of criminal history when conducting tenant screenings. It is documented that minorities are incarcerated at a disproportionately higher rate than Caucasians. Therefore, if you or your firm relies on criminal records when providing housing services, you open yourself up for liability under the disparate impact principles that we described earlier. We're not saying that you cannot rely on any criminal background check. What we're saying is that it's not going to be a primary factor in what you use, and that you're going to be very clear on how you do it. And when we say clear, the best way to be clear is to prominently post what your policy is. So to be clear, you should have a written criminal history policy, and the policy should be applied uniformly and consistently. Housing providers should not make exemptions to the policy, and again, it should be consistent with everything posted at your office. The Department of Housing and Urban Development has also provided guidance regarding the consideration of arrest records. Arrest records should never, again, they should never be considered. Just because a person is arrested doesn't mean that they're guilty. Another recommendation is to limit the policy of using criminal records for no more than the last 5 to 7 years. If a criminal conviction does exist, HUD encourages housing providers to still suggest that an application be submitted for consideration, but to recommend that the prospective tenant provide any additional information that might be helpful while reviewing the application. An example of the additional information, or as we say, the mitigating information, might be how many years ago this conviction occurred, or what type of rehabilitative efforts has the individual made since that conviction occurred. Another popular mitigating factor is the age of the client at the time of the conviction. If the client was 18 years old and now he or she is in their 30s, that makes a big difference. According to your Policy and Procedures Manual, you should know and make note of the fact that allowing an applicant to submit this type of information or additional information about their background might actually help you mitigate any potential disparate impact issues that may come up as a result of a criminal history check, especially if you're challenged. You may continue to use criminal history checks on prospective tenants. But the bottom line is that as a housing provider, you should have a carefully crafted policy to be sure that everything is being done in a uniform fashion and that you're following the Federal Fair Housing Act. Thank you so much for watching. If you found the information helpful, we'd really appreciate if you could like this video and click subscribe.